So, only to mention, Millard, which is signed before your lordship and Millard Justice Supratim Bhattacharya, Millard.
Review.
Yes, Millard. Initially, Millard, with Justice Standen, Millard, then Millard, it has
What
been.
was the issue?
But regarding Millard, there was Millard a contract with ECL, where Millard, my clients used to purchase Millard
Oh, the
diesel like rate.
Wait, please hand over the dekhe nahi hota.
Where can we expect Millard sometimes this month? It's pending for long, Millard.
All right.
From 22 Millard, the review is pending. Your lordships have been pleased to Millard condone the delay, and then Millard, the bench broke.
এটা দেখে নিন একটু। Be on any Friday. Not know
Any Friday.
All right. Let me see, because I think that matter is also fixed with the Honorable the chief, acting Chief Justice.
Right, the other matter.
Part.
Yes.
It is also must be on a Friday. And a larger bench is also on, I think, on 16th.
But the lordship makes it convenient. But usually, my lord, Justice Bhattacharya, Supratim Bhattacharya is sitting with Justice Shobhashaji.
That is why, because
Justice Shobhashaji Bhattacharya usually sits singly on Fridays. Usually. I'm good.
My lord, may I be permitted to mention one matter for listed motion? My lord, the petitioner money has been illegally withheld by the cooperative society.
What do you want?
My lord, seize and age. Yes, my lord, for listed motion.
Listed motion. Please hand over the slip. Yes, call the list.
Item number 1 to 5. But I appear for the writ petitioner. It's a 2006 writ petition challenging Section 4 and Section 6 declarations under the Land Acquisition Act 1894. Now, the initial direction to file affidavit in opposition to my writ petition was given in 2006. I do understand, my lord, the writ petition was dismissed for default on account of our non-appearance, but subsequently it was restored. Then now, my lord, we, in the interregnum, my lord, we filed an application for amendment of the writ petition, my lord, for impleading the requiring body, which is West Bengal HITCO, and my lord, to indicate the subsequent developments that have taken place after the writ petition was filed. Now, my lord, kindly see the last order that was passed.
So you are challenging the Section 4 notifications?
Yes. Because, my lord,
on what ground?
My lord, technically, my lord, the entire proceedings have lapsed. Because, my lord, because they have invoked the emergency provisions. If they have invoked the emergency provisions, my lord, it was on them, my lord, to take steps to acquire and, my lord, provide compensation and to close the issue. Now, my lord, we are still in possession. 30 years have over. We are still in possession. No steps taken in furtherance to the declarations. No compensation.
For amendment has been allowed.
Yes, it has been allowed. My lord,
you have filed the amended. You have
yes, amended petition. Yes.
Amended.
But in fact, lordship sees, my lord, the order of 8th of August 2025.
You have filed the amended writ petition.
Yes, my lord, we have filed.
We have also in this matter, my lord, I took the time for filing the affidavit in opposition.
Opposition not filed?
No.
Amendment opposition was not filed, my lord. For that is, my lord, I play some time, my lord.
Peremptory direction was given on 4th of September 2025, my lord. 4th of September, peremptory directions filed. And what the initial direction to file affidavit in opposition to my writ petition was in 2006.
Thereafter, it was amended.
Yes, it was amended.
So now you can blame them once you have amended the file.
Yes, they will file an affidavit to the amended writ petition. Now that direction was made. You have
added the requiring body. Requiring body has been added when?
Pursuant to the order of amendment. Pursuant to the order of amendment.
When? Have you served the requiring body?
4th of July 2025.
Who is appearing for the requiring body?
I'm for the requiring body, Lordship. I have no idea whether they have filed
served or not.
Have you served upon the requiring body? Show me.
Yes, we have served. The affidavit of service was filed on the last occasion.
When it was filed?
The amended writ petition was filed
এটা নিন তো। Six separate.
Yes, kindly see the order of 8th of August 2025, my lord.
ও আলাদা আমরা স্টেট
8th of August 2025. On that day, my lord, we filed the amended writ petition, and my lord, the affidavit of service was also filed on the said date.
Yes, affidavit of service was filed on 8th of August. It has been served.
এই আমাদের হয়েছে দেখি দাও তো।
দেখাচ্ছে এভিডিউট অফ সার্ভিস বলছে
It has been recorded in the order dated 8th of August.
তুমি ছিল
Do you have an extra copy of the amended writ petition? Please serve it to him.
Yes, my lord, we can give my learned friend during the course of the day. Extra copy আছে?
এই ছটাই তো দিতে হবে, পাঁচটাই তো দিতে হবে।
দেবে দেবে
The
কেন
learned
এত
The extended as a last chance. It's extended as a
Lordship,
last.
5 separate case, Lordship, all are filed. Nature may be the same, but 5 separate cases, Lordship.
Yes, my lord, one indulgence for a lordship has recorded that I'll give a copy of the writ petitions by the course of the day. Kindly makes it by, there are 5 writ petitions, but we'll give it them by tomorrow.
আচ্ছা ওটা course of this day. Yes.
Much obliged. এই তোমাদের এটা দেখাও তো।
পাঁচটাই same.
A 6 minute time for the petition of my lord, on the last occasion pursuant to your lordship's direction, my lord, a report in the form of affidavit.
Report.
That has been filed,
The
Lord.
report in the form of affidavit has been.
We have
filed.
given them in
Taken
time.
Second 3 days time to file my exception.
The affidavit in
Period is for 5 years.
Extendable,
Clause for renewal.
yes, extendable up to 5 years based on blood performance, etc.
So this is the first year. How many months have elapsed?
Maybe October
2025.
25.
But it is not even mentioned in the public domain in whose favor it has been issued. So I cannot
I
take
think-
any further steps
No, it has
also.
been disclosed in the
It is
report.
disclosed.
No,
It is-
not in the report, subject to correction.
Oh,
Yes, Mr. Kaur, where we have
I'll
disclosed
just-
that to
I'll
whom it
just-
has
The
been.
name of the successful bidder, the person has not been disclosed.
So he
Subject
has
to
made
correction.
the successful bidder a party.
But who
He
is
is a
the-
party
who is
to the
successful
proceedings.
bidder? I
He's
have
a
made-
party to the
I have
proceedings.
made 3 private respondent as party. I'm not sure who has been given. Let them specify it so that I can take further steps.
Mr. Kaur, you have not mentioned.
Yes, yes, it is mentioned. Lord, kindly.
Subject to correction, it has not been mentioned.
Kindly give me 1 minute. Number 7, Lord, it is.
Paragraph-
Where have you stated in the
Paragraph
report?
7A.
Kindly come to paragraph 7.
Yes.
Oh, sorry, এটা
So
না,
this is
no.
your
Hmm.
objections with regard to the
Hmm.
maintainability.
No, these are the statement of
Paragraph to show how he is acting.
No, my Lord, it is not clearly stated, but I can place it on record that respondent number 7 is the entity in whose favor the work order has been issued.
In that case, my lord, I will humbly submit later document this.
Mr. Kaur, I am recording your submission, but
Yes.
file a short supplementary
Correct.
report
Correct.
with
We'll do it by
attached to the-
tomorrow. By tomorrow.
Yes.
Only to this effect that to in whose favor the award has been made.
আচ্ছা যেটা বললাম না
sincerely apologize at the very outset.
Budhwar.
There was a matter that was procured before your lordship's list. It was wrongly appearing. Which is right. We mentioned in the morning because the interim order is supposed to expire today.
But that hookah bar matter.
Is the hookah bar matter? The interim order was going to expire in December. We mentioned before Justice Rai. And on 24th March, his lordship was pleased to take up the matter and extend it for a short period till the 6th today. It was supposed to appear in your lordship's list under the heading motion. For some reason, it was appearing as 129. Justice Rai's list we mentioned. I also prepared.
It's still today.
It's still.
But my lord, should not be a typical order of extension because my lord was hearing our writ petition for grant of this permission.
It needs to appear in the list.
Mr. Banerjee, you are for the other side.
I am appearing for the person whose business is now stopped.
You are for the other. You have also an independent writ petition.
I am appearing for the victim.
By whatever name called, you have also have a, because the interim order was passed on their writ petition.
When my petition was not there then. Yes.
I will hear you, Mr. Banerjee, because since today is only its interim order is still today, I
But
will
I
be
will
extending it. I will be keeping it under the heading motion.
I had made a prayer before Justice Rai to have the file sent over. His lordship Justice Rai was also pleased to direct his officers to immediately send over the file.
Alright, so and who is appearing for the state and municipality is also there.
Yes, I will intimate Mr.
Please inform
Vivekananda
all,
Ghosh was appearing.
এটা দেখুন এই দুটোর সময় একটা
This was a coffee shop. They call it hookah bar. We call it coffee shop. Coffee shop runs during this winter seasons only. If this winter passes by,
Alright, I will consider that, Mr. Banerjee, since it's
Christmas, I have lost. I could not open my shop during the entire.
Alright, because since today is still today, if it is
Any day this week, subject to, of course, minors can.
we'll consider that extension of interim order একটা supplementary বার করে দিন ইয়েতে দুটোর সময় রেখে দিন inform all the parties.
May it be at 1:15 subject to minors can convenience instead of 2 p.m. 2 p.m. We have a fixed matter at circuit bench.
There's a 110.
Busy councils will have many fixed matters, Mr. Banerjee.
One matter a day. I leave it to your lordship.
But subject to the availability of the file.
Of course, yes. Well, there
So,
is.
That I will quote.
একটা 15 রেখে দিন একটা
Grateful. Great. My lord, in this matter, Mr. Shuddha Banerjee will appear for the petitioner. My lord, praying for an adjournment. Since I have been informed by this clerk that he is not able to come to court today due to some certain personal difficulty. If I'm praying that if the matter can be fixed on 8, if my lord pleases.
You are for the petitioner.
Yes, my lord.
On whose behalf you are praying for adjournment?
On behalf of the petitioner, Shuddha Banerjee will appear in this matter.
Yes.
He has not come to court today as I have been informed.
Who is the advocate on record?
My lord, I am the advocate.
Yes. Please start. Yes.
My lord, I have instruction to take in
Yes. What is this matter, Mr.
On the last occasion, your lordship heard the matter, my lord. They prayed for extension of interim order.
Yes.
My lord raised the question, my lord. We also, my lord, raised the question before your lordship, my lord, that writ petition is not maintainable. Because, my lord, it is the, my lord, regarding to estate acquisition and land reforms act. What is the prayer, my lord, before this honorable court?
Page 19.
Page 98, my lord. A declaration that the bond standard Indian such and such, a recording in the name, my lord. Therefore, it is not maintainable before this honorable court, my lord. The electricity is the, my lord, the
You are challenging the West.
and mutation, my lord.
Yes. How is it maintainable?
Page 44 is the order where the BLR
And next page, my lord, next paragraph.
is to refuse the prayer for mutation.
C,
Page 40.
mutation.
Page 44.
Page 20. Now 20 of the writ petition. 40 order. My lord, দেখেন আগের দিন
Yes.
হিয়ারিং করেছিলেন।
It has come up for extension of interim order.
Yes, my lord.
Interim order is still which date?
No, it is vacated.
No, your lordship
Not,
was
not.
It's not
to
there.
extend unless they were able to satisfy your lordship on the point of maintainability.
No extend interim order.
I'm not praying for an extension today. Just I'm praying that the matter can be fixed.
No, my lord, that cannot be.
I'm not praying for any extension.
She's opposing.
Yes, kindly, my lord. I'm not
The
praying for.
government is, my lord, facing the railway authority, particularly. We are the state.
Satisfy me how a vesting order can be challenged in a writ petition without going before the tribunal.
My lord, Mr. Lahiri is there also. Then
Yes, yes, Mr. Lai. Yes.
He also, my lord, there.
Yes, yes.
My lord, only fix the matter for hearing, my lord. My client has briefed someone else, my lord. I am in a predicament, my lord. Can it be taken up on 8th, my lord? I am in a predicament, my lord.
Tomorrow,
8th, my lord. Kindly 8th. 8th, my lord.
8th.
8 তারিখে আমাদের একটু মনে হয় অসুবিধা হবে, কারণ আমাদের ডিভিশন বেঞ্চে মামলা আছে।
under the extension of interim order.
Yes, what is this matter?
Lordship, on the last occasion, your lordship is reminded to hear out the petition itself on the point of.
It is also not maintainable
on-
before this honorable King, my lord.
Time read by Mr. Also short passover, my lord. Short passover, my lord. Your lordship has, my lord, asked Mr. Basu to consider PNR, PNR invent.
PHR.
Sorry, my lord. PHR invent, my lord. If consider we have also brought judgment, my lord. Kindly short passover. My lord. He is addressing another court. My lord. A short.
Who is
passover.
addressing?
Mr. Basu.
Colonel Basu.
Passover. At what time?
Short passover. Any, as you feel.
12.
Fine.
Border smart. Yes, color is matter.
Item 9, your lordship, I am appearing for the respondents, Union of India, lordship.
Yes.
Lordship, I've just received the brief this morning, your lordship. I'm seeking some time to seek instructions.
May I proceed? Item number 9.
Yes, item number 9. What is this matter?
My lord,
Lordship, am I audible?
Yes, yes.
my lord, kindly come
Lordship,
to number 145 of my writ petition. That will be, my lord, this is the enhancement of the compensation amount granted to the petitioner. My lord, railway authority acquired the property of the petitioner. My lord, page 145. My lord, this is the third round of litigation. My lord, kindly consider page 145 of my writ petition. First page one.
Is that under National Highways Act?
No, my lord, Railways Act.
Railways Act?
Yes, lord.
Yes. What is the
145.
145? Yes.
And this is the second round of litigation. My lord, matter was remanded back to the appropriate authority for consideration. And impugned order at page.
Now, after remand, where is the order?
Page 149, lordship.
149. Yes. Yes.
Lordship, I received the brief this morning, Lordship. I seek some time to seek instructions.
My lord, my prayer is that, my lord, only the nature of the land, which, my lord, nature of the land was recorded as Sali. My lord, they calculated on the basis of that. My lord, my plea is that, my lord, while calculating, my lord, entire socio-economic condition of the locality, my lord, my adjacent plot owner has got higher amount because of the recording of land. That should be considered, my lord. That has not been considered.
All right. Tomorrow, the learned advocate
This is an extension of interim order.
Yes, Mr. Bose. Maintainability first.
Yes, fine. Milord, first of all, there are two issues, Milord. The land that was allowed to be retained, Milord, was subjected to, Milord, the inquiry under section 14N. After that, Milord, the land was retained. It is true, Milord, that certain portions of the land, Milord, were not corrected, record of rights. And Milord, it, Milord, went to, Milord, under Khandakhatian 1. Number one. Number two, Milord, that the power of review is, even if it is assuming unquestionable, but this power of review, Milord, exercised because the authority says, Milord, it gains its strength from 14K, under which, Milord, a general notification was issued by the government, Milord, saying that all irrigated lands, my lord, the all.
Mr. Basu, what are you challenging here?
I am challenging here, Milord, that
The order dated 5th of May 2025.
Yes, Milord, kindly.
Where is that?
Milord, yes, first of all, Milord, kindly seize the order, Milord, passed by your Lordship's court at the initial stage.
No, I will come to that. First is you are challenging this order at 5th of May 2025.
Yes.
P6.
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 The writ petition maintainable against this order.
Milord, question here is, Milord, I have two cause of action. Two. First of all, Milord, that kindly says a writ of in the nature of mandamus, B, quashing and or setting aside the memo dated 11th April, that is P4. Kindly sees also.
P4.
P4. P4. P3.
P4 49.
I'm grateful to my learned senior.
44 page. 44.
Yes.
Page?
Page 444. P4. Principal Secretary MSc and T will chair a VC. This is issued by the government of West Bengal, micro small scales. This is one of the Milord, the issues which I wish to redress.
You are challenging a tender.
I am challenging, Milord, here the action of the MSME, that is the micro small scale medium enterprise. Milord, they said, Milord, the principal secretary such and such floated a tender with this. You are requested to give wide publicity of this RF and request potential developers to participate. Further, merchant associate members and district such and such are requested to invited attend VCs. Besides, any interested organization may also be requested to participate in the discussion. Now, Milord, I say that this is, Milord, without jurisdiction. This cannot be done. And
no, Mr. Bose, yes.
Is my land. Next page, Milord, kindly sees 45.
But Mr.
Plot
Bose,
number.
prayer A, prayer C.
Milord, I understand.
Be
no, Milord,
granted.
Milord, I give me, Milord, 5 minutes. Milord, admittedly, the prayer A, Milord, is something which is to be required to be adjudicated, Milord, by the tribunal constituted under Article 323A(b). And Milord, also, Milord, the act.
Prayer C also.
Yes. Question here is, Milord, today the MSME's exercise, Milord.
Challenge that separately, but not these two.
Milord, these
but
two.
Not these two.
Milord, I tell you, Lordship.
I permit you to challenge B, but not A and C.
A and C. But Milord, since, Milord, only the judgment which your Lordship relied on the last occasion referred, that these tears at your Lordship's face, Milord, this was subsequently considered by the Honorable Supreme Court. Honorable Supreme Court, while considering, Milord, the judgment, categorically 2025 said that 34 and 36, 35, 36, Milord, that if the case squarely falls, the word squarely, Milord, I am putting emphasis on the word squarely, then, Milord, the proposition is correct. Recently, a 3-judge bench in PHR Invent Educational Society UCO Bank has held. It could thus clearly be seen that the court has carved out certain exception when a petition under Article 226 of the Constitution could be entertained in spite of availability of an alternative remedy. Some of them are as where the statutory authority has not acted in accordance with the provisions in the enactment in questions. Enactment in questions, Milord, Milord, 1996, I will rely on a judgment. It has acted in the defiance of the fundamental principles of judicial proceeding. It has resorted to the invoke of the provisions which are repealed, and when an order has been passed in total violation of the principles of natural justice, it It has, however, been clarified. The High Court will not entertain a petition under Article 226 if an effective alternative remedy is available to the aggrieved person or the statute under which the action complainant has been taken.
Mr.
itself-
Bose,
yes.
it's the discretion of the court.
Yes, madam.
After all, it's the discretion.
Madam,
of the
I tell
court.
you, Lordship, if I can.
After all, it's
No,
the
no,
discretion of the court
absolutely.
whether to entertain or not to
Absolutely,
entertain.
absolutely. Milord, no quarrel with this proposition. But Milord, whether I'm entitled or whether I'm correct in Milord pursuing your Lordship's judicial conscience, when your Lordship talks about it, the
A and C.
no, I agree. I bow down, Milord. Even then, Milord, I know.
Two prayers.
No.
All right, I allow you to press prayer B.
Milord, if I go to the tribunal today, Milord, I assuming, Milord, whether I can, I'll take Milord 5 minutes. I know, Milord, it's a judicial mind. I can reopen it at any time. On the last occasion, I confronted with this storm, Milord, but I succeeded. Milord, Milord, the process. Abuse of process, why? Section 6, subsection 3, Milord, if the estate acquisition proceeding was allowed, and I was allowed to retain a particular land, Milord, it is not a fundamental right, but it is a constitutional right to hold the property in accordance with law. Milord, after so many years, when I, Milord, made a
Even if that is
representation.
So, Mr. Bose, division bench, not single bench.
Division bench.
Go before the
Yes,
division.
Milord.
Then, Milord, if it is, then Milord, this particular P4.
The West Bengal Land Reforms and Tenancy Tribunal Act bars the single bench jurisdiction entirely. Only by the division bench.
Question is, Milord,
Go before the division bench.
Milord, only, Milord, last. A careful perusal of the aforesaid judgment leads us to the conclusion that where an efficacious alternative remedy is available, the High Court should not entertain a writ petition, which your Lordship is consistently saying.
Mr. Bose, even if I accept your this submission.
No, in matters falling squarely within the domain.
Yes, even if I accept that a writ petition is maintainable, has to be before the division bench. Because some of the reliefs claimed are false within the specified act, you directly approach the division bench because single bench jurisdiction has been taken away. Under the West Bengal Land Reforms and
Since my interim order is
division.
No, Milord, I am not here, Milord, to waste valuable time, Milord, by making unnecessary, unreasonable argument. I was contemplating, Milord, government, Milord, in certain cases, Milord, moves with an ultrasonic speed, Milord, in order to deprive citizen of its fundamental right, legal rights. Now, I cannot combat with this situation as an individual, Milord, and sky. So, Milord, if I can, the interim order, Milord, expires 9th of this month. I need to contact my client, Milord, because in this time, between this period, if the government, Milord, proceeds, even if suppose division bench is not agreeable with what the leave has been granted, because your Lordship is only giving me a leave to approach the Honorable Division Bench as per the Supreme Court. It may so happen, Milord, the Honorable Division Bench is likely to reject the and go ask me, Milord, go there. Now, Milord, in the transit, Milord, I may lose everything. So, Milord, because, Milord, I tell you, Lordship, the moment I say that you have not corrected my record of rights, despite there being an order, the government has, Milord, reopened, Milord, the entire proceeding only on the basis.
Mr. Bose, your basic challenge is with
No, I write, Milord, right.
So if that is so, you have to approach before the
Milord, in the intergeneric
basic claim.
Milord, in the
entire foundation of this writ petition is on
Milord,
that.
they have preferred an appeal, Milord, before the Honorable Division Bench, intra-court appeal against the order. They have a right. Question here is, Milord, this
No, who has preferred an appeal?
My learned
State preferred appeal, my lord, has passed the order passed by my lord Justice Parthasarathi Sen on 22nd June. His Lordship, my lord, pleased to set aside the proceedings.
The maintainability point was kept open. Even then,
Maintainability point, my lord.
They 17 this.
That remains, my lord.
Milord, the mindset.
17th of.
Milord, this is in the prime location in Bankura.
22nd June, my lord.
22nd.
Appeal copy dena judge.
No, sorry, my lord. 18 June. 18 June.
Since they have preferred an appeal, Milord, your Lordship, Milord, kindly extend the interim order, Milord.
We have taken this point, my lord,
Because
regarding
this order is still alive, Milord, and contested, Milord, hearing. The court had passed an order.
You can Approach the division bench because the division bench is in session. How can I
Malad,
now-
Malad, the passionate mindset of the state, Milord, in pursuing the appeal.
18 June,
Then,
Milord.
Milord, the passionate persuasion of the state, Milord, like a private litigant in this matter, Milord, it suggests, Milord, in no uncertain terms, that the state is abetting the project, Milord, in a way by which, under which, Milord, I may lose all right, Milord, in the transit. And the prime location, the property is situated in a prime location, Milord. I will lose everything. And your lordship, Milord, has immense experience in the bar, Milord, that the bar does not have any control, Milord, with regard to the speed of a
Milord,
proceeding.
I'm opposing this, Milord, submission, Milord.
He has every
This is
right
not
to oppose
correct,
everything. No, this is absolutely incorrect,
Not the correct
maybe.
submission.
This may be entirely incorrect. I respect your perception, which is frightfully narrow. Created by this time, Milord.
No. This is absolutely wrong, Milord.
না তাই জন্যই তো করতে চাইছো না তোমার যে অভিমানটা সেটা আমি বুঝি
আমাকে বলতে দাও তুমিও বলো আমিও বলি
This order of 19th of May has been set aside.
Yes, Milord.
And the maintainability is kept open.
19th of May you have challenged here.
This read
That has
petition
been set
filed by
aside.
the 19th.
Now what remains, Mr. Bose, is
Proceeding
the
pending,
read petition.
proceeding pending. Proceeding is pending, 14D proceeding.
Maybe, but it has been set aside. That was also one of your prayers.
Yes.
It has been allowed.
Yes.
This was.
Now it's before the division bench.
No, there are two orders.
It remains
Yes,
to be
Milord.
decided by the single bench.
Milord,
I'm grateful to your
there are
lordship.
two orders. Kindly see. Supplementary affidavit din na Joshua.
Twofold.
No. After this order was passed, Milord, the first order, first interim order, Milord, kindly cease. The first interim order.
Suppose after this order has been set aside and the matter is pending before the division bench, not be proper.
Cannot be
part
made.
two.
No.
That's the parent order. Which
No,
you are
Milord,
challenging.
I tell you, Lordship. Well, kindly cease. Kindly cease by 22nd May order first. The said read petition.
After this,
Milord,
order has been set
supplementary.
aside.
Just a minute. Supplementary, Milord. Supplementary.
Supplementary.
Paragraph 3. Supplementary is what is file is supplementary.
Why?
No, I don't.
Now, when
22nd May, Milord, this was not the condition. This was not the situation, Milord.
after 22nd May, 18th
Yes.
of June,
Why?
I cannot go into why. Good, bad, indifferent, the order which is challenged, that has been set aside. So relief granted.
Kindly cease. The
Nine-
court say no.
Been set aside.
22nd May, Milord, when this order was passed, the 19th order was not served upon us. That is why I'm requesting.
Well, that is not the correct submission, Milord.
That is why the kindly cease.
The order
It is
dated, what relief has been granted?
only Milord, one paragraph. Milord, I Milord, no, Milord, the elasticity of your lordship's patience, Milord, for which I bow down to my lords. It is pertinent to mention order tapara. 18 June. Order 18 June.
18th June, I was looking at 18th June order.
Yes.
Yes.
For filing, the facts reveal for filing the writ petition, leave was granted on 19th May. Second paragraph, clause A. Mr. Bandopathay, learned senior government advocate, duly assisted by Mr. Botopal, learned advocate appearing behalf of the state, its functionaries following facts reveal. For filing the instant writ petition, leave was granted on 19th May. Notice regarding filing of the writ petition received served on 20th May in the office of the learned GP, High Court, Calcutta, as well as in the office of the jurisdictional BLRO. The matter was mentioned before this court on 22nd May for urgent hearing on 22nd May 2025 at 1:15 p.m. On the same day, on 22nd May at 1:15 p.m., the court expressed his intention to take up the matter on the same day at 3 p.m. This court requests the learned advocate for the writ petitioner to intimate such fact to the learned advocate for the state, and accordingly notice was served upon the learned advocate for the respondent, intimating that the instant writ petition would be taken up on 22nd May at 3 p.m. On the same day, 22nd May at 4:25 p.m., the instant writ petition was taken up for hearing when this court passed an order for stay of all further proceeding in connection with the review proceeding suo motu bearing case number such and such under section 14(3) of the such and such act, read with rules such and such of the rules against miscellaneous case number such and such in the matter of TA. At this juncture, such and such advocate appearing on behalf of the writ petitioner draws attention of this court to the order number 5, 19 May 2025, as passed by the jurisdictional PLRO, that is respondent number 6, herein it is submitted that by such and such that on 19 May 2025, the writ petitioner Sri Borun Kumar Ghatok personally came to this court for swearing affidavit before the oath commissioner, which prevented him to appear before the respondent number 6 authority in the hearing of the aforementioned review petition. It is further submitted by such and such that from order number 5, dated 19 May 2025, as has been annexed at page number 15 and 16 of the supplementary affidavit as filed today, it would reveal that the respondent number 6 authority disposed of the review petition in a haste manner without affording any opportunity to the writ petitioner to present his case of defense. It is thus submitted by such and such that action of the respondent number authority is susceptible in view of the fact that on the day of hearing, 22nd May 2025, no submission was made on behalf of the respondent that the review petition of the proceeding, which is under challenge in the instant, has already been disposed of. Such and such submits that it is a fixed case for passing an appropriate order in respect of the order number 5, dated 19 May 2025, as passed by the respondent number such and such. Such contention is, however, opposed by Mr. Bandopadhyay, learned senior advocate, government advocate. It is submitted by Mr. Bandopadhyay that from page number 13 to 16 of the supplementary affidavit, as filed by the writ petitioner, it would not reveal anywhere that the respondent number 6 acted in a biased manner or with utmost haste. It is further submitted by Mr. Bandopadhyay that from the order dated 19 May 2025 passed by the respondent number 6 authority, it would reveal that no one represented on behalf of the writ petitioner even to seek an accommodation. It is further contended by Mr. Bandopadhyay that from the earlier orders as available at page number 13 and 14 of the instant supplementary affidavit as filed today, it would reveal rather that the respondent number 6 authority had given ample opportunity to the writ petitioner to present his case defense against the proposed view. On being asked by this court, it is, however, candidly submitted by Mr. Bandopadhyay that on 22nd May 2025, when the instant matter was taken up for hearing, he did not get any instruction from his client regarding disposal of the aforesaid review petition. On careful consideration of the entire materials as placed before this court, and after hearing the learned advocates for the contending parties, it appears to this court that from the chronology of events as quoted in the foregoing paragraphs, it reveals to this court that the respondent number 6 acted in a haste in disposing the said review. It further appears to this court, despite service of notice of the instant writ petition in the office of the jurisdictional such and such BLRO, respondent number 6 made no endeavor to communicate his advocate on or before 22nd May 2025 that the said review petition has been disposed by him on 19/5/2025. This court has noticed that considering the urgency of this matter, this court granted leave to the writ petitioner to file the writ petition on 19th May 2025, which is why the writ petitioner had to remain in High Court for swearing affidavit on the said day. This court thus finds sufficient justification on the part of the writ petitioner for his absence on 19/5/2025 before the respondent number 6. Considering the entire events as discussed supra, this court considered that since this court is in season over the aforementioned review proceeding, and also considering the fact that the aforementioned review proceeding was disposed with unnecessary haste, this court exercise of its plenary power and to meet ends of justice quash the order such and such as passed by the respondent number A. Mr. Bandopadhyay such and such is hereby directed to communicate the gist of the order positively in course of the let the matter be listed on the date fixed.
Show me the order dated 19th of May 2025.
My lord, your lordship kindly turn to page
Supplementary affidavit.
supplementary page 15.
Supplementary affidavit page.
Page 14, my your lord kindly first take up page 14.
জজ সাহেব তো 19 চাইছে, আপনি 16 দেখাচ্ছেন।
আমি দেখাই না, আগে থেকে একটু আগে আসি না,
আরে
অসুবিধাটা কি?
সবসময় পেছনের দিকে হাঁটলে
না না না, একটু আগে থেকে আসুন না জজ সাহেব। But page 14, my lord, order serial number 3, your lordship got it?
Page 14.
Page 14 of my supplementary affidavit.
Yes.
Order number 3, my lord, dated 14th month. On behalf of the respondent Borun Kumar Ghatok, Dhrubojyoti ki Advad unit
Mr. Bandopadhyay, please give.
appeared understand the submitted
19টা দেখা
supplementary দামে দর্শক
দর্শককে দিয়েছি তো না
থাকবে তো।
Yes, yes, I've got that.
My lord,
তো আপনি 19 অর্ডারটা পড়ুন না।
হ্যাঁ যা পড়বো 3 নম্বর থেকে আগে আসি না। Order dated 14 May 2020 on behalf of the respondent Borun Kumar Ghatok, Dhrubojyoti appeared before the undersigned and submitted a prayer for extension of time. Their prayer is considered and the next date of hearing is fixed on 19. 25. The same is communicated to the respondent this moment. That is, my lord, the order of the 14th May. They appeared before the authority and prayed for time, my lord. Next date fixed on 19th. On 16th, my lord, the proceeding such and such is received by the office such and such, my lord. Next date, my lord, your lordship, my lord, which is, my lord, your lordship, my lord. Next page, my lord, 19th, order dated. The case in is taken up today for drawing instant proceeding such and such. On that date, my lord, no one appeared before the, my lord, authority and prayed for any time. And they, my lord, filed a writ petition before this honorable court on 19th. There is no intimation to the, my lord, authority that they are preparing this writ petition on the 19th.
Yes.
Therefore, my lord, the order, my lord, the case was taken up and passed the order on 19th. As because, my lord, the authority has no knowledge about the, my lord, 19th. Whether they have preferred any writ petition before this honorable court, as they not appeared, they are not preferred any time, there is no intimation to the authority. But there is no such, my lord, purpose in this order, my lord. They preferred appeal thereafter when the 19th, mentioned before this honorable court 22nd. This matter was second 22nd.
Please kindly come to page 14 of the supplementary affidavit.
14.
14. So this order of 5th of May 2025, you have challenged in this writ petition.
I have,
Prayer
yes.
A.
Prayer A. Yes, yes, correct.
So this is under challenge in the writ petition.
Yes, no doubt.
So now, this was the proceeding for review.
Right.
Now, at that time, it was pending. You had challenged the initiation of that proceedings in this writ petition. Now, good, bad, indifferent, during the pendency of the writ petition, the proceedings was disposed of, concluded against you. Now, in the meantime, when they disclose that this review petition has been, or the review proceedings has been disposed of, you brought to the notice that you could not be present for XYZ reason.
I was here.
For XYZ reason, for which the coordinate bench was pleased to set aside that order of 19th of May. So the cause of action with regard to 5th of May now culminated with the order of the learned single judge, thereby setting aside that.
Correct.
That is under challenge before the Honorable Division Bench.
Correct.
So I cannot now go into the issue of
forget.
So that has been decided.
Discussed. Right.
So
very,
now
very.
it remains. So now, if this matter, since the matter is pending, that's the effective relief, Mr. Bose. If it is pending before the division bench, nothing remains now, sir.
Millard, I tell your lordship, there are two aspects. Your lordship is absolutely right that the order.
What interim protection you are seeking?
Today, Millard, I am saying, Millard, if the order, Millard, is set aside, the proceeding is still in, final order is set aside, the conclusion of the proceeding, review is still there.
Approach the division bench.
Review is still there.
Mr. Bose, I cannot touch that.
No, your lordship, I am not saying.
Order setting aside.
Today that is under
the
challenge.
entire matter is before the division bench.
But Millard, if your lordship on the one hand says, Millard, if your lordship says, and it is true, Millard, from the record, that the very initiation of the proceeding is without jurisdiction.
Now I cannot go into that.
No. Proceeding is still there.
Yes.
No, kindly record my submission. The proceeding is there.
Proceeding.
The proceeding under section 5, the 5. No, I am submitting. Just record my.
Yes. No, I will.
Yes, that the jurisdiction of the authority in proceeding under section 14T, Millard, it is without jurisdiction. Act number 1, based on Millard 14K, and for which why I say so, because the High Court said that when an inquiry has been made under 14A, the general notification cannot, Millard, take away my right. That is my understanding. It may be wrong. So
what I am trying to.
Your lordship is absolutely right that the division bench is the decision of the matter. So it is a judicial propriety demands. I cannot.
You can approach that court for an interim.
Yes, Millard, kindly. But so far as the MSME part is concerned, the MSME, the second part.
MSME part cannot be segregated.
Millard, MSME today, in view of the setting aside of the order, the MSME, Millard, division bench has not, Millard, with an ultrasonic speed, they filed an appeal. They did not pursue this appeal to be listed. Kindly have the charity.
Mr.
But that
Bose,
is a good,
nothing
bad,
pre-
indifferent.
Nothing prevents the respondent
first-
from making an application in the pending appeal.
Yes,
Paying
yes.
for an interim.
Only,
protection.
only.
Keeping tight. You file an application. I give you that.
Oh, my lord, I bow down. I bow down. My lord, 19 and 20 paragraph of the 22nd May order. 19 and 20.
Yes.
Considering the two interim orders, considering the urgency of the situation as discussed supra, there shall be a stay of all further proceedings in connection with the review proceeding, suo motu bearing case number such and such, in the matter such and such. It is further ordered.
Which
That's
paragraph?
1920, page 267. No. Oh, sorry. 19 and 20. 22nd May order.
Yes.
19 and 20. Considering the urgency of the situation as discussed supra, there shall be a stay of all further proceedings in connection with the review proceedings such and such, in the matter as pending before the respondent number 6 till the last date of July 2025 or till further order. It is further ordered that status quo be also maintained in respect of the writ petitioner property, particulars of which has been mentioned in page number 21 till the last day of July. Miller, this order I am saying, Miller, this status quo. If this part is extended, Miller. It relates to prayer B of the
consequence to paragraph 19.
No, Miller, no.
This is consequence to paragraph 19.
Prayer B, Miller, kindly see, it has Miller strengthened my situation for the simple reason.
The status quo is because a review application was filed. Review proceeding was
Good, bad,
pending.
indifferent, I challenge.
Yes.
The court passed an interim order considering urgency.
Allow
Ultimately,
me to
Miller,
make my observation.
sorry, Miller. I
You have
apologize.
challenged the initiation of that review proceedings.
Right.
So the coordinate bench, upon being prima facie satisfied, passed an order of stay of all further proceedings of the review.
Correct.
Now the effect of for that, since that order of stay was passed, this is the consequential order of status quo.
Right.
So that property should remain in that stage as it was.
Right.
Yes.
So now, after that, during the pendency, that review petition was rightly or wrongly disposed of. In a
Yes.
way,
That has been challenged.
you brought to the notice of the court.
Court
that
set
was
aside.
set aside.
Right.
Now they have challenged that order before the division bench.
Yes.
Now this order of status quo as well as the stay.
No, they have challenged,
What
Miller.
else to
They have
that?
challenged. No, Miller. They have challenged, subject to correction, the subsequent order which set aside the order. They did not challenge this order. Two orders. Now, Miller, this order, this part, if this is so, Miller, this order protects me. We don't. The threat is, Miller, prayer B.
To approach the
Miller,
division bench.
threat is at prayer B, Miller.
Ashun,
Miller, they are setting up, Miller.
please approach the division bench. The
আমিও জানি না, আমি করিনি তো।
Whether the mat was
আমি ওটাই advocate নই।
Section 5?
application.
Yes.
Whether if the appeal is not,
I don't know.
whether the appeal is registered.
Section
Well, I have not preferred appeal, another state of law here.
The court, in view of such fact, the court, this honorable court, your lordship's court, refuses to extend the interim order. Otherwise, I will prefer an appeal against this order also. Otherwise, I will limit it.
I've said to entertain to entertain this prayer, I've said. তাই বলেছি না?
হ্যাঁ হ্যাঁ।
The prayer
Yes, yes, yes,
for
yes.
such reason me to record refusal, I can also record that.
My lord.
Go for
Great.
deeply obliged.
চলো।
Yes.
Then, my lord, I beg to appear on behalf of the petitioner. My affidavit of service, my lord.
Yes.
My lord, the petitioner, my lord, belongs to the exempted category of land loser, my lord, on account of the ancestral land of the petitioner having been acquired for construction of National Highway 6. Now, my lord, Regulation of Recruitment Act 1999 and the corresponding memorandum of 2002, my lord, cast a duty on the state government, particularly the district magistrate, to prepare a combined list containing names of the eligible family members of land losers. And my lord,
Who is
consideration.
for the state?
My lord, I have served, my lord, by hand.
Who has been briefed?
But that I have not checked, my lord.
Why? You have stopped this practice nowadays.
My lord, the difficulty is delegation, my lord. I am being, my lord, candid to your lordship and apologetic to, my lord.
When have you served upon the state?
My lord, the government was served on 15th of December 2005.
Mr. Bandyopadhyay.
25.
Yes. Yes.
Yes. So, my lord, the duty is to, my lord, prepare a combined list containing names of eligible family members of land losers, and, my lord, consideration of their candidature for, my lord, appointment to various, my lord, state government establishments, state government undertakings, and, my lord, statutory bodies. Here, my lord, my grievance is that despite, my lord, several applications having been made by the petitioner, my lord, this exercise has not been undertaken. I have also sought for, my lord, disclosure of information pertaining to preparation of the combined list and details of the candidates, my lord, who have been, my lord, appointed apropos this
You have
particular.
applied under the Right to Information Act.
That also I have done, my lord.
So if no reply is given, you have a remedy under that act.
Yes, yes, my lord. I have preferred a statutory appeal was also preferred, my lord.
Then-
Your lordship will find, my lord, no, my lord, information
Then second appeal is also
have
there.
been disclosed, my lord. That has not been availed of.
So you can take that recourse.
Yes, my lord. That's a separate issue altogether, my lord. Here I am on the fact, my lord, on the issue, my lord, that they have, my lord, failed to discharge, my lord, their statutory duty. My lord, may I hand over, my lord, the act to your lordship, my lord. Copy of.
So you have made a representation.
Yes, yes.
Where is that?
Yes, my lord. The representations made by the writ petitioner, my lord, appears at page, my lord, 32 and 36, and
Which
thereafter,
is the appropriate authority?
my lord, it is for the DM, my lord, unless, my lord, a committee has been constituted. The memorandum also I have annexed, which is appearing at page 27. My lord, the memorandum, my lord, basically lays down, my lord, the procedure and the modalities for determination of, my lord, the exempted
So you want the
category.
land loser certificate?
Land loser certificate, as well as, my lord, inclusion of my name in the combined list.
Where have you stated that in the representation?
Yes. Lordship may kindly takes up my demand of justice, my lord.
Not in the representation.
Representation, my lord. Lordship may kindly allows me.
শঙ্কর পরে কপি তোর কপি চলো।
Yes, my lord. তাই মহাশয়, page 33.
33, yes.
Yes. তাই মহাশয়ের নিকট, my lord, second paragraph. আমার সবিনয় প্রার্থনা, এই যে উপরোক্ত জমি অধিগ্রহণের কারণে দয়া করে ল্যান্ড লুজার সার্টিফিকেট প্রদান করেন, আমি তাহলে বিভিন্ন সরকারি দপ্তরে চাকরি পাওয়ার ক্ষেত্রে কিছুটা সুযোগ সুবিধা
We wanted only the land loser certificate.
My lord, this has to be done, my lord, by inclusion of my name in the combined list.
Yes, where is your demand of justice?
Yes, my lord, it is at, my lord, page 49 it starts. And page, my lord, 52, my lord, is the.
Yes, Mr. Bandyopadhyay.
My lord, it appears from page 32.
Yes.
The land belongs to the DT.
Yes, yes.
Yes.
Yes, yes.
I don't know, my lord, whether, my lord, this.
Initially, my grandfather was issued by.
জানি না, হতে পারে। In which purpose, my lord, the land has been, my lord, acquired? I don't know, my lord. It not appear from this representation. And if
Consider this prayer for issuance of the land loser.
But if there is any scheme, my lord, if there is any scheme of
Mr. Bandyopadhyay, communicate your decision.
all right, my lord. Your lordship, my lord, if there is any scheme, my lord. এই কবিতা আমি নিয়ে নিলাম। তো তুমি আমাকে জেরক্স কয়েকটা দিয়ে দিও। কিসের জন্য জমি নিয়েছি?
National Highway 6.
RS 197, LR 1197.
My lord,
Plot number is 197, RS 197, LR 1197.
LR per page, paragraph 3, my lord, it has been stated, LR
1197.
1197.
The petition
Well, for the student, my lord.
Yes.
Not referring the application of the petitioner for reference on the section 18. Under section 18 of the Land Acquisition Act.
Now, why?
Now, my lord, it was there. It is pre-2013 Act acquisition.
Yes, but when this notice was issued,
Yes.
it's within time.
I am coming. That's
Within time.
I am coming. If a logically turn page 34, everything will be clear.
34.
The reason for rejecting my
Reason for rejecting your prayer for reference.
yes.
Yes.
Your lordship will find that the representation 20th 7 2020 and along with the release submission, my lord,
Page.
page 34.
34, yes.
From the top, the award was passed on.
Oh, yes, yes.
My lord will find at the from the first line. 22nd August 2030. My lord got it. Prior to 2014 Act and the compensation disbursement the award dated the compensation 2020 Act, the proceedings remain governed by the 1894 Act and the petitioner cannot claim any benefit. This is not my case also. Now I can turn to my objection. Page, for that we can turn page 17.
No, Mr. Rai, you have not sought for any reference.
That is their case, my lord. I am coming. That is why, my lord.
According to you, you sought for reference.
I raised an objection. Whether the objection can be turned to be reference or not, that I'll.
Page
17.
17.
Yes, this is a 12-2 notice. When I got it.
Yes.
Date of payment is 29/8/2013. At the bottom, my lord, I was not present, so I will be guided by section 18.
So you received the check on 5th of March 2014.
Now I'll get into page 18.
Yes.
This is the objection which was filed at the bottom left hand side, 29/8/2013. And this is admitted. It is not a case that I have not filed. Now, my lord, can you turn to page 19, paragraph 3. So I raised objection regarding the valuation without accepting the amount. It is
without no, after accepting.
no, without accepting that amount.
No, no, you have received the check in full.
Yes, date, my lord. That is why, my lord, at the bottom, my lord will find
5/3/2014.
And this objection was filed on 29/8/2013 at the bottom. Page 18, bottom, left hand corner.
Oh, so according to you, you have filed an objection prior to receiving this check.
Yes, it is admitted. Kindly turn to page 20.
But you have received, thereafter you have received the amount without...
Yes,
without
no, page 20.
Page 20, yes.
So my objection, if I raise an objection, after that I accept, that is. So this is the amount which is subsequently been offered. Now I can turn to the reason assigned for my rejection.
Yes.
Now I can turn to page 25.
25.
Yes.
Yes.
The crux of the decision, my lord will find. Second paragraph, the petition was served, my lord will find. Good. There is a notice under section 12(2) of the 1894 Act on such and such, and thereafter the petitioner submitted a written objection on such and such, disputing the adequacy of compensation. However, this objection did not contain any express request for reference to the civil court under section 18. On 15 February 2014, the petitioner received the award compensation under protest. Can you record that? On 15 to 2014, but no formal application for reference was filed within the statutory period of limitation period, raising the subsequent representation of the petition 2020. So this is there no express prayer was made for the purpose of referring. Now, Maharaj, can you turn to the provision 1, section 18.
The Land Acquisition Act একটু দেখুন। Yes.
Any person got it was not accepted the award may written application to the collector required the matter be referred to the collector for determination of the court whether his objection to preservation of land, the amount of compensation to whom to be payable, or the apportionment of the compensation among the persons interested. Two things, my lord, I have to draw a lot of the specific form. There is no specific form. I have to show my intention that I have agreed by the compensation amount. And that was interpreted by this court also.
Yes, please. It was within 6 weeks of 12 notice.
That's notice. There is no dispute.
Yes, now, yes.
Now, my lord, what is the form? Or what is the requirement to be made by the awardee for the purpose of seeking reference? There is no such form. So I have to express my dissatisfaction regarding the quantum.
There are two things, Mr. Rai. One is, first thing is that you have to require a reference.
Whether expressly, whether this.
And while making that prayer, you have to state the grounds of your objection. Twofold things are necessary.
My lord, if you are logically considered.
Because the first part of that section 18
that was
says,
interpreted. That was interpreted to what extent we have to. This is quoted in 1974 Calcutta 1396.
Yes.
May I read out? I hand over to your worship, my lord.
Yeah, yeah.
Yeah, yeah. 1974 Calcutta, page 1396.
Calcutta page?
1396. 1396. Calcutta 396, sorry.
That's why I astonished. You are saying 1396.
No.
396.
396.
That is why I was astonished. 1396, so many pages in the Calcutta volume.
74.
Yes. At that time, the pages were more. Now it has reduced. Yes.
The learned element of the respondent, paragraph 4, sought to distinguish the facts of the present case from that were available in the case before the division beings. I will refer by pointing out that the case in receipt of the amount withdrawn was endorsed on the back of the petition, in which the protest against the award was ventilated. But in the present case, although the application was made on 11th November 1963, the protest was clearly put on record. A separate receipt was granted by the lawyer for the claimants who withdraw the money without adding in that receipt itself any word to convey the amount was withdrawn under protest. Furthermore, Mr. Roy, advocate for the respondent, emphasizes what has been said by
the name of the advocate is also telling, Mr. Rai.
Reported such and such, that where a person receiving compensation money stated only in the application under section 18 that he would receive the money under protest, the amount was not received under a properly recorded protest, and the application would be barred under section 13(2) of this second proviso. Having heard the learned advocates of both the sides, we are of the view that decision of the division bench reported in such and such The collector is a binding authority which we should follow. More so, we find ourselves in complete agreement with the respect of what the learned judges of division bench have said, that said in that judgment. We need only to add whether a clear receipt is appended on the back of the protest application or where the clear receipt is granted in the present case. A lawyer for the party in a separate document does not make the difference at all in view of the law regarding the effect of second proviso of subsection 2. So long the protest against the quantum of award is appearing on the record, in fact, in the application made by the claimant, the second proviso such as such, then it was held that yes, not only the application praying for reference under section 18, but also was another independent application on the same day. By signifying the protest and conveyed that the claimant was agreeable to withdraw the money under protest without prejudice to the right as reference under section 18. Therefore, the amount which was withdrawn was in fact under protest, and we comprehend that the land acquisition collector has authorized payment of that amount only in pursuant to the petition which claimant has clearly
Sir,
stated that
the issue here was, in that matter was, whether withdrawal of the amount,
without recording protest.
that's one part. That's one part. So you may say, yes, when I have raised an objection, any withdrawal thereafter is subject to that objection. No issues on that.
No, it was recorded in the receipt order that acceptance is with objection.
Even if that is not there, that can be accepted. But the question is whether you have paid for this reference.
My lord, kindly consider 2014.
Specific reference.
Volume,
Specific
no,
prayer.
it is the earlier one. Kindly consider this
Specific prayer is required.
2014 volume 1 CLJ page 393.
2014
volume 1 CLJ page 393.
Yes.
Your lordship kindly consider the facts of this case. Oh. Mr. Bishwajit Dey, your lordship will find, it is recorded, my lord will find the bottom. Mr. Dey, landed advocate appealing for the state respondent, submits that since there is no specific prayer made, my lord got it.
Extra copy আছে
দিয়ে দিচ্ছি।
Where is 1991 SCC 1966?
It was deferred.
I've seen that. That is why. Where is that?
That is not the
Because that decision, that principle was borrowed.
borrowed from there. And ultimately, what is held, my lord? Not only that, the Guwahati judgment was it was forwarded to the chief minister of the state.
Yes.
And the same thing, my lord, the pattern of the point, my lord. So it is the oh. 8. No.
What decision?
This is 1994. It is Madras law you have done.
Why are you going to Madras?
No, because what is fallen for considered, that was entirely considered. And what is the reason? That is why, my lord.
No, here it has been recorded in that paragraph, and more so in the. That is why I wanted you. Do you have the gadget 1991?
But it was not with me, my lord. It was not with me, my lord, because it was referred.
Not carrying with your gadgets.
No, my lord. I am still, my lord. I am Tony's advocate.
How have you downloaded it from where?
It is no. It is mine.
That is why.
No, that is why I am not in a position to subscribe SCC online or like that.
This Supreme today, here it is available in that.
Yes.
So where is that? Please find it out from there. You are carrying your mobile. Yes.
And my lord, if you lordship can consider,
Because in 1991 Supreme Court, Mr. Rai, it was specifically observed that when there was no express averment in the reference application, that the referring claimant was seeking a reference on his behalf and on behalf of the three held that it was surprising the state have acquired the property, would take technical objections regarding the entire member of the
Yes,
claim.
on that score, one it was considered.
This was considered by the division.
And considering that the division bench here also there no this is a specific submission made by the state that there is no reference sought for, objection was raised.
Yes, what do you say?
No, actually, I have not instruction. I have not received.
What instructions? This is the
You know,
point
what
of
does-
law. Point of law, yes. Please give it.
Yes, I have just the division bench judgment. I have-
Go through this judgment. Point of law, what instructions your officers will give? He is not submitting anything. Everything, your records he is submitting.
I have not shown any documents. I have
copy of those.
The collector has no power to suo motu refer them under section 18, my lord.
Collector has the power to?
Not power to suo motu refer them under.
Not suo motu. He has raised an objection. It is not a question of suo motu reference. It's on the basis of his objection. So you have only said that there is no express request for reference.
That is my only point, my lord.
Yes, that has been answered by the Honorable Division Bench. Considering the Supreme Court, please look at the underlined portion.
Though it is for persuasive value, 94(1), that received under protest, my lord, we used to, that word is there. Paragraph 4, my lord, will find that is the only consideration. It was held that on the basis of such endorsement in the payment register.
Which paragraph?
Paragraph 4, my lord. If you are logically consider paragraph 4. Payment received with protest, my lord.
Here, Mr. Rai, you have not made that endorsement received under protest.
That is why two things. First thing, I have to raise protest, or at the time of acceptance, no, it is recorded. While consider the order repute.
But in the there you have not said. In the order, it has been recorded.
No, in the order it held on the date of acceptance.
The petitioner received the awarded compensation under protest.
Yes.
But there it has not been recorded under protest.
But,
In that.
no, it is a 12 to notice. My lord, it is not a payment register. It is a 12 to notice which is communicated indicating this is the amount. In the payment register, I have to record that at the time of receiving the same. It is not that in this notice I have to mention.
No, Mr. Rai, this judgment which you are referring to, here it dealt with an issue whether this protest only would make.
That is why.
We need not go to that because.
My lord, because there also I have accepted the money with protest. My lord will not find that endorsement from here because it is a communication by the state regarding indicating this is the amount of compensation you are liable to 12.2. I have to record protest in their register from whom I have accepted the check. It will not be reflected from here, my lord. That is why the authority have said that at the time of accepting the money, I have recorded
protest.
On protest.
And even if you do not make any formal application,
Yes.
that recording.
That recording will suffice the purpose. That is the
That
why.
is for that.
So, but apart from that, I am coming down to one stage lower also.
Yes.
Well, I have to file affidavit, my lord, against all this. Considering
Okay. What affidavit? Point of law will file affidavit.
1 week time,
The